When I was in grade 8, we had a sign by the clock in our classroom that said, "The time will pass, will you?"
Good afternoon, everyone. Welcome. I would like to call the meeting of the Committee of Adjustment to order. We would like to acknowledge that we are meeting on the traditional lands and treaty territory of the Saugeen Ojibwe Nation, which includes the Chippewas of Nawash, unceded First Nation, and the Chippewas of Saugeen First Nation. We also recognize the Métis, whose ancestors shared this land and these waters. We extend our gratitude to all Anishinaabe and Métis peoples and their descendants, past, present, and future, who continue to care for and inhabit these lands and tend these waters. Let me first start by introducing the members of the committee. On my far right, Mr. David Cramp, Mr. Ed Ormsby, Mr. Cam Hall, who's the vice chair, and on my far left, Mr. Peter Toville, and Gabe Pucci, who is Secretary Treasurer of this committee, and myself, Terry Williams, I am the chair. The municipal planning staff in attendance, Denise McCarl, Manager of Planning Services, Helena Fascinato, Planner, as well as Gabe Pucci, Development Services Assistant. I want people to understand that this committee is legally required to make decisions that conform to the Provincial Planning Act, as well as the existing county and local official plans. Based on those documents, as well as any additional relevant correspondence, the municipal planning staff have prepared detailed reports and provided this committee with their recommendations. For those who are here in person, or joining us remotely via Zoom, as well as the applicant or their representatives, you will have the opportunity to speak. I will call upon you at the appropriate time. Anyone wishing to receive notice of this decision on any of the or on this specific application being heard today may do so by calling 519-538-1060, extension 1120, or make an email request at planning@meaford.ca. Before we begin the public portion, I would ask if the members of the committee have had an opportunity to review the minutes of the last meeting. Are there any changes necessary? May I have a motion then to accept the minutes? Ed and Peter, second. All in favor? That motion is carried. This is a meeting of the Committee of Adjustment to consider an application for consent under Section 45 of the Planning Act for the lands known as 125627 13th Side Road. This file was previously deferred from a meeting of October the 30th, 2024. Before we begin, I would ask the members of the committee if there is any reason, pecuniary or of a general nature thereof, which would preclude them from making a unbiased opinion on this file. No, hearing none. I previously deferred, and the last time we did this file on October 30th, I've had several conversations, and my recusal was not because of a pecuniary interest. It was because of a knowing of the clients. Upon further review and looking at all of the additional information that has been provided on this file, I choose not to recuse myself from this today. So let us begin. Gabe, can I ask you to please summarize the application?
Thank you, Mr. Chair. First of all, notice was initially given on October 10, 2024. Then the application was deferred during the public hearing of October 30, 2024, as you previously mentioned. The applicant requests consent to adjust lot lines between two properties, also known as a lot addition. The proposal is to sever lands from 125, 627, 13 Side Road to be added to the vacant lands at lot 14, concession 8. The severed lands will be 42.2 hectares in size with approximately 229.5 meters of frontage on 13 Side Road. The retained parcel will then be 5.8 hectares in size with approximately 114.3 meters of frontage on 13 Side Road. Thank you, Mr. Chair.
Elena, are there any additional details on this file?
Yes, thank you, through you, Mr. Chair. So following the deferral, we did meet with the applicant as well as with the county planner to further discuss this file. The municipal staff opinion would remain that we don't see that it conforms with local policy. The lot line adjustments are very restrictive in the agricultural or prime agricultural areas. And when we look at how we would interpret the legal or technical reasoning, say if I have a property and I want to put an increased septic size and I don't have the lot area, then I could look into a lot addition from my neighbor. And that's something that we would look into supporting. This type of proposal, we cannot support it. And the reason is to access the landlocked parcel, and there are supportable options. So the preferred option would be to merge the parcels together. So then a further undersized remnant lot would not be created, or to obtain access through a right-of-way easement. And the county is of the same mind with that as well. So I'm happy to answer any questions. Thank you.
Does any member of the committee have any questions relative to the planning department?
If I may, I gather that the severed parcel would be about 5 acres of, give or take? The small, pardon me, the retained area would be about 5 acres, is that correct?
5.8 hectares.
Yes,
In
hectares.
size,
sorry.
yeah.
For argument's sake, if it had been 1 hectare, would that have made any difference in your decision?
No, it would still be an undersized parcel for the agricultural area. If it was a rural area, then it's a different ballgame, but because it is a prime agricultural area, the way we interpret the policies is more restrictive.
So it's really, it seems to come down to, it doesn't fall into the category of legal and technical issues that might allow it to be adjusted.
That's the municipal interpretation, in the counties as well, as they've noted.
Thank you.
Are there any additional questions? Yes.
Yes, through you, Mr. Chair. I have a couple of questions, but I think I would refer them to the applicant's planner, I think.
Yeah.
Okay, thank you.
Any for the planning staff? I have one. How many area or I'm in looking at the GIS mapping and so forth, there is a number of rural residential properties in the immediate neighborhood, both on Gray Road 12 and Side Road, 10th Side Road, etc. How many of them were rezoned to rural residential from potentially agricultural?
Yeah, so those lots to the west of the property across the river there. So rural residential is lots that are less than 2 hectares in size or 5 acres. Looking at those, a lot of those houses were built, in the 60s, 70s, and I can't speak to planning policy at that time and why the creation of those lots was permitted. But this specific parcel is agricultural. So we wouldn't look at those ones when reviewing this specific lot line adjustment.
So you're not aware of any parcels in the immediate area that were rezoned from agricultural to rural residential?
If a parcel is agricultural, but it's less than 5 acres or 2 hectares, then it is deemed rural residential, even if it is still zoned.
But no, I was looking specifically at severed and rezoned as rural residential.
I'm not aware. And looking at those lots, it looks like some of the homes have been there for quite some time. So I can't speak to the previous,
Okay,
but I'm not aware of any, no.
thank you. I think I would ask then that the applicant or your representative, we would like to hear your comments, please.
All right, thank you very much. Good afternoon, everyone. My name is Genevieve Scott, and I'm with Questa Planning Consultants. And as you know, we were retained by the Dorgelo's 2 system in the subject lot line adjustment application. So I'll just quickly run through a few things just as a reminder. I won't go into too many details. Everybody's aware of this file already. But if we could just skip to slide 2. Just looking at the 2 parcels that we're talking about there. So property A has the Dorgelo's homestead on it, and it's cash cropped. And that property is about 22 hectares right now, so it's undersized. And then parcel B is a landlocked parcel, which is about 26 hectares, also currently undersized, and it has also been used traditionally for cash cropping purposes. So if we just, if you want to switch to slide 3, please. I think everybody's probably been to the site to take a look around. So we're all aware that in this particular area of the municipality, it really is dominated by a rural residential type of landscape. There are some agricultural uses. There's a barn that is across to the west, but there's a lot of houses in between these subject lands and the one existing barn. So there's no issue related to an MDS conflict or anything that would constrain that use. And just to the northwest there, we have an institutional use on that's abutting one of the subject properties as well. So just to give a little bit of background in terms of parcel Bs, we could just switch to the next slide, please. In late 2019, 2020, there was an institutional land use that was applied for, and that was eventually located off Grey Road 12. And during this process, there was the church group severed the lands that are east of the Big Head River. And that's how we ended up with that landlocked parcel, which the Dorgelos purchased with the eventual hope to build on that parcel, hopefully for a family if they come back to the area. So we just switch to 5, please. So yeah, the proposal before you right now is for a lot line adjustment. There's no new lot being created as part of this proposal. And the intention is to reduce the size of property A, which would maintain a property size of about 6 hectares. That would include the Dorgelo's residence and accessory structures, well and septic infrastructure. And then enlarge property B, which will afford the landlocked parcel, road frontage and legal access. And we'll bring that parcel up to official plan minimum lot area requirements. So one thing that we talked about a little bit at the last meeting was with respect to provide different ways of providing access to that landlocked parcel. And so at the time I confirmed I had previous discussions with the county as well as municipal staff prior to Helena and Denise actually being municipal staff. And it had been confirmed that, we could build on that parcel through a right of way. And that right of way approach is really still the preferred option by municipal planning staff. We're still of the opinion that the lot line adjustment makes for a more logical layout at the end of the day. So I just wanted to give the committee an opportunity to consider a few examples that are fairly similar to the Dorgelo application. If we could just move to the next slide. This is an application that we had just completed, got approval, I think, last week on it actually, up in Township of Georgian Bluffs. And so this was a situation where there was two farms. Mr. Marcelo wanted to take a large chunk of one farm and merge it with the other, which meant that the one lot became smaller, more of a residential sized lot, and then obviously expanded the one farm parcel. Interestingly, with this one, this was actually in the Niagara Escarpment Plan area, which tends to be a more restrictive policy for the most part. But in this situation, we did not need a Niagara Escarpment development permit because their definition of development is a change in land use, structure, or building. And because there was no change to any of the uses proposed as part of this application, all we needed was the consent. So so that particular approval authority did not see, that this would be impactful. So I'll just take you to a next example. This example was I think from 2024, and this was down in Southgate. So in this case, you had two undersized parcels that we're dealing with. The one neighbor wanted to purchase a large portion of the other landowner's lands in order to, what he had intended to do was actually try and consolidate enough land to get lot area to permit an on-farm diversified use. The landowner with the larger lot didn't really want the land anymore, was tired of maintaining it. So they applied for a lot addition. There was no concern from township or Grey County staff with this lot addition, despite the fact that there was no legal or technical reason for it. So these lot additions do happen. So I'll just switch to a more local example, if we can switch. So this one was, I don't know, maybe about 5 or 6 years ago. This is the old almond orchard property. So in this case, there was a residential lot that had been severed off this parcel, and they needed some land in order to put a new septic tank on. So their preferred option, there might have been some opportunity to put it elsewhere on the existing lot, but they wanted to move it east, which was, and so they needed some land from the orchard area to the east. So rather than just take the chunk of land they needed for the septic system, they looked at the lot configuration and thought, well, it probably makes a lot of sense to just take the remainder of the lot to the east and add that to the residential parcel. Makes for better lot configuration overall. So was it necessary to add the lands to the residents, all of the lands? No, but did it make sense? Was it logical? Yes, probably it was. So this is just to demonstrate that there has been recent precedent in both Grey County and Meaford where the approval authorities determined that lot additions are appropriate, regardless of the size of the addition. Primarily based on the facts that impacts would be either non-existent or minor, and that the resulting lot layout is logical. So next slide, please. Oh, actually switch to 12 if you don't mind, please. Next one. Oh, sorry, next one, I think. Keep going. Oh, yeah. So in some, well, there's one other comment. So our position is also sort of reiterated by those the comments that we received from OMAFRA, which essentially said when municipalities and approval authorities are looking at these lot adjustments, and what they're looking at, and what is considered minor, is not just the size of the area, it's also potential impacts on agriculture, taking a look at the surrounding land use and deciding whether or not, impacts are minor, as well as not just looking at the area itself. So the province does not specifically define minor in the provincial policy statement, and that's to allow approval authorities some latitude and flexibility when looking at these lot line adjustments. So it remains our opinion that the subject lot line adjustment does meet the intent of policy. It brings one of the two lots, they're both undersized, one of them into full conformity. It will consolidate the majority of the farmland, and there's not going to be any impact to surrounding agricultural operations. It allows the access to the landlocked parcel in the most logical manner as far as we're concerned. And we feel it has merit and should be approved. Thank you.
Does any member of the committee have any further questions? Yes, Ed.
Through you, Mr. Chair. Thanks, Genevieve. That was very informative. This is a difficult decision for us to make because common sense, and in my case, common sense tells me this is what should happen. But at the same time, planning departments in the municipality, the county, and the province are basically saying no. So I have to be sold on the idea that I can ignore those people. I mean, we want these young people to get what they need. I mean, and the families been they're generational families, and but it's tough to say yes to something that professionals are saying no to. So
I understand where you're coming from, and that's why I thought it was important to include the comments that we received from OMAFRA, which is basically, there's a reason that I mean, this is a direct quote from OMAFRA. There's a reason that they don't define minor in the PPS. And then he told us, go look at these other things. Well, or this is also what approval authorities need to be looking at, right? I was a little surprised too. I mean, I know that from Helena mentioned in her original report that they did not consider this a legal or technical reason. First of all, I mean, I just gave you an example where there was no legal or technical reason and they still, allowed a lot addition. But that surprised me because I've had discussions with county staff, Scott Taylor specifically, who said, access from our perspective is a legal or technical reason. So I don't know about that myself. So I think people, I think sometimes the word minor is problematic, right? Because if this was 5 acres, what is minor? Is it 5? Is it 10? Does it depend on what you're putting it toward? The last time we talked to the province when they were updating the PPS, they said, you need to get rid of that word. As long as you're not creating a new lot and you can demonstrate that there's no offsite impacts related to MDS, you're not going to be, impact. It's important to not impact what's going on there agriculturally. So why are you doing that? Because it just leads to questions. Okay. So in the Southgate case, it was 7 or 10 acres. So that's minor. Why is that minor? There's no legal or technical rationale for it. The guy didn't want to mow his lawn, so he gave it to the other guy, so I think, same with the almond property, there was, the technical reason was the septic, but they took much larger parcel, because it made sense. There was a very small slip of land for the farmer to be able to access across the orchard. So that made sense. So is that lot addition minor? I wouldn't say that was minor. So there is latitude.
Yes.
thank you. In all 3 examples you gave us, which was quite good, but the municipality and the county and the province was all on board, so that makes it a little bit different for us. But what I thoroughly feel, and I'm not a planner, when the original property was severed, when the church was built and the property from the river was severed back, landlocked property shouldn't be created. So that makes me think it makes common sense to let the applicant have what they want. So that's just a comment.
Yeah, and I think they went through the navigable, I don't think they did not go to Committee of Adjustment for that. I believe it was a navigable waterway severance. Yeah.
Mr. Chair.
Yes, Ken.
I look at this and very much agree with Ed that logically, this seems to be the way to go. I look at it and I say, okay, if one can make a legal argument that supports a position, then you have a legitimate case to make. And in this case, I think you do have a legitimate case to make because, as you pointed out, it does not result in a new lot. And I think you're at the point where you can say that you do fall within that legal and technical. So from the point of view of myself, I can see the argument being made, although the things seem to point the other direction. I think sometimes one has to say, what is the evil that is being addressed here by perhaps saying we're not going to do this, other than we're abiding by the letter of the law, which can be argued. You know, it can be argued there's a case on the other side. There's always 2 points of 2 points to make on each side. So I think that you've got a good case there from my point of view. Thank you.
Any other questions? I have a few. I assume that the reason you do not want to go through farm consolidation is because the intention is not to hold it strictly agricultural forever. Is that correct? That there is a plan to build on the merged lot, agricultural lot, in future?
Yes, my understanding is that Mr. and Mrs. Dorgelo would like to retain the building option on that farm parcel and ideally in order to build for their daughter, but I don't know for sure. And if she comes up, she wants to come back to the area. They want that opportunity and they don't want to lose that opportunity.
The next question is, knowing that these discussions happened prior to the purchase of the lot, was the thought process that eventually you could get approval through a severance?
I'm not sure. That was before I was involved in the application. Mr. and Mrs. Dorgelo might be able to answer that.
But I mean, and I'm suggesting perhaps the applicant can answer that question in the sense that I think it goes to the context of what was happening here. If you were told in advance that was going to be problematic, what was the rationale, or have things changed since the property was originally bought? Sorry, if you, yeah, appreciate it.
Sorry, yeah, we were never told that there would be any issue to build back there. We were always under the assumption that if that we would obviously have to find some way to get that land frontage, which obviously we own the land in front, so we assumed there's got to be a way, right? Like it's a doable thing. We didn't see it as a obstacle.
I'm going to come back to Elena for comment about that. Genevieve, just one more. You cited, and I'm familiar with the approval that was done for the severance here in Meaford. I'm curious though, with respect to the other two, did you go back to Grey County and say, you know, why are you saying no based on these other two where you seem to have had no objection. Did they give you an answer?
Not really. I mean, I reached out and spoke to Grey County about the Southgate example. And Mr. Taylor indicated that he was going to look into sort of the rationale behind that. He didn't get back to me as of this point in time. I didn't, and the Marcella one, which was from Georgian Bluffs, that was our file. And that file, we received positive comments from Grey County, I think perhaps because it's a different approval authority. They didn't mention having a concern related to the lot adjustment because they would look at maybe provincial policy, but they don't really apply their own policy on that one. But they do have an opportunity to comment, and the comments were positive. So I'm not too sure the rationale. It just seems to vary depending on, I don't know, maybe sometimes the size of the area or the end result. It's a judgment call. It's an opinion, right?
Thank you. Yes, Denise.
So I just wanted to jump in and thank you, Mr. Chair. I think I wouldn't get hung up. My professional opinions don't get hung up on, these are not precedent setting. So I wouldn't get hung up on what the other ones are because you actually don't have enough information to go on that these are the same enough to apply those. The NEC one, for example, the Niagara Escarpment Plan has very different parameters. The one in the township of Southgate might be almost exactly the same, but we don't have enough information in front of us today to be able to determine that and why it was done. The other issue is they could be mistakes and things that shouldn't have been done, and that doesn't provide a precedent to future mistakes. But what I would focus on myself and what I'm going to ask you to do is to determine in your own that you feel that you can make a decision one way or another and not worry about these other ones. I think you have a lot to sort out between you, and that's where I would go with it. And certainly there is some interpretation, and I think that is where sometimes planners disagree. And you may be wondering about that. It's not as black and white as what an engineer would argue about. These aren't formulas where you get the number. So I would just focus on that. And I think if you have any questions for clarity on, specifics related to this, I'm happy, and Helena's happy. She knows more than I do about this, but we would never just stand out on a limb on our own. So we also follow directions of what the county wants to administer in their own official plan. So if this is what they've provided as their official comments, we wouldn't dismiss them and say, well, on another one, you said something different, because we just don't know enough about those other situations and they may be different. On the one in the municipality of Meaford, it is a little bit different in that case because they had farm buildings and a house on two separate parcels that were part of the same original operation. Why were they separated? Maybe that was the first mistake. And that did create an issue where that house just didn't have the room it needed to be able to do the septic. Could it have been done differently? I don't know. I wasn't one of the people that worked on that file, but I do remember it because it was going on just around the time when I started here. So I think they're all different, and that's why I wouldn't call them precedents per se, but I understand that it is frustrating when we kind of seem to be applying the policies interpretive, like especially if the county appears to be interpreting differently on different ones. I think I would agree with my friend, Ms. Scott. I think they should define what minor is. I think that has created a lot of angst for planners generally. We don't know the difference of why it would be minor. I think what we're trying to go by the intention as well. And I think that's what you folks are doing as the decision-making body. You're trying to go with the intention of the policy and is it offending the intention? And I would just stick with that if that makes sense.
Thank you. Just one question. My laptop powered off, so I can't go back to it. When the lot was originally purchased, the landlocked portion, I thought it stated in there that Gray had expressed concern that they were going to have to do something to access and it would be difficult to sever. Did I misread that?
Just for clarification, was that in the county's updated comments, or I'm not familiar with
in the original comments.
in the original.
Helena, I might be able to answer that. I don't mean to
Okay.
interrupt through
Yeah,
you, Chair.
absolutely.
I, in the county staff report, I believe Cassandra mentions that we had previous discussions. So I
Yeah.
did have discussions with Scott Taylor a few years ago now, sort of pre-COVID, where we had started initial discussions. It's also when I spoke to Liz Buckton at the municipality, and we were talking about it, and we looked at, well, we were talking about the right-of-way option at that point in time as something that they would consider. And then we just kind of, COVID happened and things happened and it was dropped, and now we've picked up the request again. So that's where that would come from.
Okay, thank you. Cam,
Just want to confirm, so for the purpose of my understanding this, we really are saying because this adjustment doesn't fall within the definition as the municipal boards have said of legal and technical issues, that is really the problem that we have with approving something like that. Is that correct?
Yes, that's correct, through you, Mr. Chair. And there are supportable options. So merging the two properties, that would create a farm-sized property of about 48 hectares.
Yeah.
And it wouldn't be left with a undersized parcel. So merging would be our preferred option, or the right-of-way access.
But the
as
applicant
well.
has made an argument that they do fall within legal and technical issues, given that we've got the minor border adjustment that does not result in a new lot. They're making that
Yeah.
argument.
So this is where our interpretation
Interpretation is
differs,
what it comes
and
down to,
yeah.
yes. Thank you.
any additional questions, comments? Ed?
I don't want to drag this out. What's the repercussions if we approve this and the county is going to comment on it again, obviously, or will they?
I'll jump in because I just pushed Helena out of the way. The county's not going to comment again that I know of. So what they will do is we'll give them, so whatever the decision is, they'll get a notice of the decision. And it's my understanding there are no appeal rights by the county, nor is there any municipal appeal rights. So in the olden days, like 3 years ago or whatever, there were many cases, and you'll find out if you go to OACA this year or any other year, there are cases where in the past, or they'll be still talked about, where the municipality might appeal the committee's decisions on some things. And my understanding is those appeal rights don't exist anymore. So there's very limited bodies that have appeal rights for consents.
Any additional questions? Yes, David.
Mr. Chairman, through you to Genevieve, and to address what Ed had said earlier, this is as hard a working couple as you'll ever find. Our issue again is to deal with municipal, county, and all of that. I fear that this has become a self-inflicted problem. When the lot was created that ended up landlocked back there, it was never landlocked before. Would you agree with that? Not until it was severed.
I mean,
Lot B.
When the church,
Yeah, but
yeah.
That piece of property back
technically-
there is not
technically,
landlocked until it gets severed.
That's correct. When they, yes,
Yeah.
yes, unless they, well, kind of, I mean, it's a lot of river, so.
But it was part of a 100-acre working farm for years. Maybe.
The one that fronted, yeah.
And the other thing about, when we talk about the undersized lots, in that we have two of them out there, one that was a planning issue where it got approved at undersized. The one that is landlocked, it's undersized solely because of the river. And it cut out only that much land. Is that fair?
I think, yeah, I would say so. I don't know the original parcel, whether all of those houses down
Well-
further south were part of it at one point, but I'm not sure of the, but
All I'm
yes,
suggesting is
yes.
that the undersized lot is undersized, not by poor planning by anybody's.
Oh, that's correct.
Yeah.
That, that's,
This was simply the river that created this. That's why it's the size that it is.
that's correct. Yes.
The other thing that I would offer to the committee members is this Pandora's box that you open. And the other thing, there's an out here, which is merging the properties. And we bring everything into conformity by doing that. It's just not the response that even some of us would like.
Through you, Mr. Chair. I think we're all agreeing this is a really difficult decision. And I think Ed, you said it very well the first time on your first comments. My problem is the fact I still think I want to uphold policies of both the county and also the municipality and the planning department. To me, that's important. I don't like the idea of doing precedents, even though we've talked about maybe don't be, but it could well be. Because once one stunt starts, then they all start coming. So I'm going to be voting against.
Any other comments? Is there anyone online that wishes to speak? Was there anybody here?
No. Through you, Mr. Chair, there was someone from the firm of Genevieve, like Yanni, but I don't know, not anybody else, yes.
Okay. Last opportunity. Is there anything else anyone would like to say? Okay. Then, can I have the suggested decision, please, and the conditions?
Through you, Mr. Chair. The recommended decision from the municipality and the planning staff is to refuse the consent application. And there's no conditions attached to that. However, we also have prepared a decision to accept in case the vote goes in a different direction. Thank you.
Is there any discussion about the suggested decision? Are we ready to take a vote then? All in, actually, I guess I need a someone to move. Peter, second. All,
We have that motion read again, please?
Yeah. Through you, Mr. Chair. The recommended decision from the municipality of Meaford is to refuse the consent, and there are no attached conditions to this. It's just the refusal. Thank you.
all in favor? All opposed? We now have a second option. You could read those.
Through you, Mr. Chair. In making the decision upon this application for consent, the Committee of Adjustment is satisfied that the proposed consent application complies with the intent and direction of the provincial policy statement, County of Grey official plan, and Meaford official plan. The recommended decision is to grant provisional. The new decision would be to grant provisional consent up to 3 conditions. The first one, that the applicant meets all the requirements of the municipality, financial and otherwise, for the certificate of consent to be issued. The second one, that the severed parcel arising from the consent be permanently merged on title with the abutting lot, and any mortgage on that lot be extended to the enlarged parcel. And the third one, that the final R plan be provided to the municipality for review to the satisfaction of the municipality. Thank you.
Does any committee member have any comments or questions? I have one. What is the potential that the municipality is not satisfied with this decision?
Through you, Mr. Chair, since it's now conditional approval that's recommended, we would follow these conditions and just make sure that they're satisfied. for number 3, where it's to the satisfaction of the municipality, that's just ensuring that the registered plan is for taxes and the dimensions are correct and stuff. It's not, we don't put any further input.
Any other comments, questions? May I have a motion then? And second, Cam. All in favor? That motion is carried. Next steps, please.
You, Mr. Chair. The applicant will receive an email with the decision and notice of appeal period, and now you can take off the sign from your property if you're ready. If you didn't take it off already. Thank you very much.
Thank you. Yeah, I just wanted to make sure. Yeah. Just
So if I may, Mr. Chair, through you, the next item would be the
Yes,
correspondence
yeah,
that we
just-
added. Okay.
just wait till everybody signed that. If you don't approve,
Oh, that's her. This is the decision, so they.
if he doesn't agree with the decision, he does not sign it.
That's the conditional, right?
Yes.
There should be concurrent.
No,
The one was, the motion was defeated, on the first one.
Yeah.
Oh, okay.
so. Pardon? You voted in favor of the conditional, so. Oh, that's the second page.
Yeah.
Right, the next item is Denise, the OACA conference, or Gabe, I'm not sure who's.
Well, through you, Mr. Chair, I went to 2 conferences in 2023 and 2024, and this year will be actually a pretty much local conference because it will be held in town of Blue Mountain. If I'm not mistaken, it will be in May 2025, and we, according to Denise, Denise, of course, she's the keeper of the budget for the planning department, and there is budget for definitely for members of the community to go to to this conference. So I found them very explicative and very useful for this for committee of adjustment, and I learned a lot of not just terminology, but also you do case studies, and for example something like this could come out, and it's for planners and also for people that are not actually planners like me. So it's really, I think it's an experience to be done, above all if you decide to stay in the comedy, if you decide to be a comedy member for years from now, I don't know if Denise wants to add something to this.
I don't have anything to add, but you're all welcome to register, and we can submit your receipts like you did before, and we will get them reimbursed for you. So it'll be a little different because you have maybe the full conference this time. You might want to decide to stay over just because, I mean, you don't have to because you can drive back, but you can if you felt like you wanted to be part of some of the evening stuff. Might make sense.
Is,
14th, is it? Okay.
yeah, is the agenda and topics and everything available for us to look at?
I think I attached.
It's attached.
Okay.
It looks really good if you.
Yeah, Denise, and through you, Mr. Chair, the staff that provides the the courses, the workshops are a member of the OACA, so the Ontario Association of Committee of Adjustment, but also collaborators and external speakers, there are planners, but also there are very experienced chairs that do workshop for chair and vice chair. And there are experienced secretary treasurers that have been doing this for years, and they're not a development services assistant and a secretary treasurer. They're actually big municipality, big cities. They have like a focus secretary treasurer, and City of Toronto, they have like various committee of adjustment. So their core workshops, they're very focused, and where you can get a big amount of information for this. So it's well done, and I see the benefit on doing that. Now this year I won't be doing it because I can announce it now. This is my last committee of adjustment. I resigned from the municipality for a new municipal job. So today is my last dance. For sure.
Where you
Collingwood. I live in Collingwood, and
Let's see someone, okay, good.
thank you.
Good for you.
Yeah, I shaved. I shaved for the last dance. Yes.
Any questions regarding the conference? Okay. Next meeting is scheduled tentatively for April the 23rd. And do we believe there will be files for that?
There are a couple of files.
There's quite a few files.
Yeah, there are probably
Yeah.
two minor variances, and I think a consent or two consents.
3 or 4.
Three or four, okay, so probably between 4 and 6 files to be reviewed, yes.
Good. All right. All right. With that, we are now adjourned.
Thank you.
Thank you.